You're watching Herald Now. Would love your feedback on Ubers this morning. We've been talking about just your experience as a user. Ryan at nzherald.co.nz is the email address. Ryan at nzherald.co.nz. We'd love to hear from you. 21 after 7 now. Contractors or employees? The fate of Uber drivers across New Zealand is hanging on the result of a Supreme Court case in Wellington this week. They're fighting for the right to be treated as employees rather than contractors, describing Uber contracts as repressive and changeable at the stroke of a pen. Lawyers for the multi-billion-dollar global rideshare company say the drivers are contractors and are taking the argument all the way to the Supreme Court. Jennifer Mills is an employment lawyer and law expert who's been following the case. Jennifer, good morning.
Good morning, Ryan.
Lovely to see you, Jennifer. So it's still before the Supreme Court. They've wrapped up, have they? But we're waiting on a result?
That's right, Ryan. So the second day finished yesterday. The Supreme Court retired and the decision is reserved. And I did watch part of the live streaming yesterday. And it was interesting that the justice's focus was very much on the level of control which Uber exerts over the drivers and also their integration into the business. And much was made of the fact that a driver can be terminated if their ratings fall below a certain percentage or they don't accept a certain number of rides. And we know that the Employment Relations Authority, the Employment Court and the Court of Appeal found that the drivers are in reality employees. And my assessment of it, having viewed the hearing, is that the Supreme Court is likely to find in favour of the Uber drivers and find that they are employees. But the difficulty we have, Ryan, is the proposed changes to the employment legislation, which introduces the gateway test. And if that does pass into law, and it looks as though it will, then Uber drivers will be very clearly independent contractors. So this might, in fact, be a Pyrrhic victory for the Uber drivers, where they could only be employees for a very short period of time before the law changes.
Right. What is the consequence, the financial consequence for Uber? They've got to pay holiday pay, they've got to do a whole bunch of other stuff. This is why they don't want it, right?
Well, that's right. There'll be leave consequences, access to personal grievance mechanisms, and tax issues. So I would imagine if there is a period where we have the Uber drivers' status cleared up and they are employees prior to amendment to the legislation, the consequences on the service will be significant and consumers will be paying more for the service. Yeah,
interesting. And so you said that there's the law change that could come along and bump this off if indeed the Supreme Court finds in the way that you believe that they would. What about those drivers who are using not just Uber, but then clicking over to Bolt and Ola and other services? You know, if they don't get a ride on one, they'll jump onto another. Surely they can't be employees.
The analysis from the Supreme Court, in my view, will apply to all rideshare providers, I would have thought. Certainly, there'll be some similarities in facts. There are only 4 Uber drivers who are bringing the case that the unions are acting for, but certainly all Uber drivers will be impacted by the decision and many rideshare providers. But I think that what we'll see from the Supreme Court and their analysis of the Section 6 of the ERA will be helpful for our interpretation of that provision in the Act more broadly. So looking at the distinction between principals and contractors more broadly.
All right, Jennifer, great analysis as always, and we will await that Supreme Court ruling. Jennifer Mills, employment lawyer and law expert with us. The email address, ryan at nzherald.co.nz.